The appeals court just overturned Judge Clancy's decision to keep Quadajah Johnson locked up before trial. In their terms, she should not be sitting in jail waiting for trial and should be released with conditions. And before you even ask, no, the state cannot just decide to keep her locked up after this ruling. When people do the most, I do the analysis. Let's go. Okay, y'all, let's talk about exactly what the appellate court just did. By a 2-to-1 majority rule, the appellate court just reversed the detention order put in place by Judge Clancy, and they sent the case back to Clancy's trial court with instructions to do one thing only, and that is to set conditions for Quadajah Johnson's release. And no, that's not a suggestion. It's a directive. It's a directive that's coming from a higher court, the appellate court. Now, I'm hearing things like they don't have to release her now and, they have 30 days to respond to the appellate court. Well, let me just clear that up right now. The appellate court has ruled, and they've already decided that the state did not meet its burden, and detention of Quadajah Johnson without conditions is not justified right now. So the trial court can't simply reorder detention based on the same arguments, but is there any way that Quadajah can still be detained? Well, that depends, and only in very limited and specific situations. First of all, there would need to be new evidence or changed circumstances that occur. For example, if the state comes back with something substantially new, like there have been new threats, or if witness intimidation has taken place, or if there are new facts showing the danger of having Quadajah released during pretrial, or if any of these changed circumstances occur, then the state would file another detention petition. Another way of detaining Quadajah Johnson is if she was to violate any of the established release conditions. And what this means is this. If Quadajah Johnson is released and then she turns around and violates monitoring conditions, if she improperly contacts witnesses, or if she possesses a weapon, specifically a firearm, then the state can move to detain her again. And the last but most rare and difficult way of detaining Quadajah Johnson again is further appeal. This means that the state could try to take it up to the Illinois Supreme Court. But the Supreme Court does not have to take the case. And to be honest, this kind of pretrial issue, it's not always accepted for review. So what's most likely to happen next is that the lower court, Judge Michael Clancy's trial court that is, will do this. He will set strict conditions for release, things like no firearms or ankle monitoring, etc. And then he will order her release under those conditions. So to be clear, the judge doesn't have discretion to ignore the appellate ruling. It simply doesn't work that way. So the bottom line is that the state lost this round. They can't just keep Quadajah detained anyway, but they can act later if something changes or if she breaks the rules while she's free on pretrial release. So let's talk briefly about why the appeals court made that decision. Under Illinois law, specifically the Pretrial Fairness Act, the default is that people should be released before trial unless the state proves three things. First, the evidence strongly shows that the defendant committed the crime. Second, that the defendant is a real and current danger to people or to the community. And finally, the third thing the state has to prove is that there are no conditions like monitoring, no guns, etc., that could make the defendant safe to release. Well, the key issue in this case is that the defense argued and the appeals court agrees that the state failed to prove number 2 and number 3, and that's the danger and no possible conditions. Let's talk about how the judges saw it. The majority, the 2 judges who won, basically said this, that this was a specific personal situation, not random violence. This means that the majority felt that the September 8th incident came from a relationship conflict, not gang violence or a child predator on the loose type situation. So essentially, the appellate judges believe that Quadajah Johnson is not a danger to the community and that she should be granted release as she awaits trial. Did Quadajah Johnson win? She did. She just won a battle that her attorney's been fighting since she was first detained on December 3rd. Does this appellate ruling increase the likelihood that Quadajah is going to be found innocent due to self-defense? Not at all. This court has nothing to do with guilt or innocence. Quadajah Johnson is still charged with 6 counts of first-degree murder, and she still has to face trial. It's going to be up to a jury to decide whether she is innocent or guilty for ending the life of Ramika Blackman on September 8th of 2025. Well, that's all I have for now, but I'll be back with another video to further break down the appellate judge's ruling and to elaborate on the 2 judges' decision to release Quadajah, as well as the 1 judge who dissented and who strongly advised against the release. So yeah, y'all, Quadajah Johnson has won the battle, but she has a long and very difficult fight ahead if she's hoping to win this war. If you enjoyed this video, please give it a thumbs up and share it with someone who can use this message. Subscribe to the channel if you haven't already done so, and leave a comment down below letting me know your thoughts. Do you think Quadajah Johnson is going to make a run for the border, or do you think she'll be on good behavior during her pretrial release? Meet me in the comments. We can continue the conversation there.